OpenAI walked out of Oakland with a win, but Bill Sabat was celebrating a procedural exit, not an acquittal on the merits.
This is Musk v. Altman Daily. I'm Devin, and the AP just put into a headline what this whole trial couldn't quite put into a verdict. Can anything besides profit actually steer AI?
I'm Cassidy. Today we're tying off those Tesla and SpaceX email subpoenas and tracing where the mission drift question goes next. Spoiler, it runs straight into the AG offices and the SEC.
The trial is a record now, not a proceeding. Let's see what that record actually says.
Akron Legal News with Matt O'Brien.
The soaring costs factored into the trajectory of OpenAI, which began in 2015 as a non-profit dedicated to developing AI for the common good and is now a capitalistic enterprise valued at $852 billion. As San Francisco-based OpenAI and other AI companies move toward historically large Wall Street debuts, the trial also raised questions about whether anything but commercial interests can steer AI's future.
The AP's Matt O'Brien is basically writing the philosophical obituary for the federal case. And the headline does part of the legal work for us. Clues, but no verdict. A jury ruled for OpenAI on May 18th, but the dismissal came on latches, not on whether a nonprofit can ethically restructure itself into an $852 billion capped profit entity. Those are two different things, and O'Brien is the first Wire reporter to say it that plainly.
And the kicker for me is Bill Sabat, OpenAI's attorney, out there in front of the Oakland courthouse, talking to cameras like he just won on the merits. That's a victory lap for a procedural outcome. The question of whether Altman and Musk's 2018 email thread about needing billions per year immediately justifies scrapping the nonprofit mission never even got touched.
Which is why Florida is the live wire now. The AG's consumer harm complaint is the only active docket where that underlying question, can anything but profit actually steer AI, might get a substantive ruling. Two different legal theories, same philosophical core, and only one of them still has a judge.
And the SEC's September review deadline is sitting right in the middle of all this post-mortem coverage. If the AP is now on record saying the trial left the mission drift question open, that's exactly the kind of atmosphere an SEC disclosure review lives in. Step back with me. If this case is supposed to be about broken promises at a nonprofit, why would the court care about Elon Musk's emails at Tesla or SpaceX? What could those records possibly prove?
Hi, I'm Mark, and I'm the human behind the podcast you're listening to right now. I'm really looking to learn more about what our listeners like and don't like about our shows. So if you're listening and you have opinions about these podcasts, I would love the chance to chat with you personally. There's a link in the show notes with how to get in touch, or you could email me at hello@lanternpodcast.com. Thanks. Now back to the episode.
So the core theory is that Musk's own conduct and motivations go straight to whether he was actually deceived. Musk's lawsuit says Sam Altman and Greg Brockman misled him into donating $38 million to OpenAI by promising it would stay a nonprofit dedicated to AI for humanity. And then they took billions from Microsoft and restructured into a for-profit subsidiary. But OpenAI's defense is that Musk wasn't some innocent donor who got blindsided. They say he had his own for-profit plans for the company all along. And per trial reporting from MIT Technology Review, Brockman testified that Musk actually pushed for OpenAI to create a for-profit structure himself. If emails from Musk's other companies show him discussing AGI strategy, competitive positioning against OpenAI, or his own commercialization plans around the same period, that becomes evidence of his state of mind. Did he really believe in the nonprofit mission, or was he already thinking like a rival entrepreneur? There's also the unjust enrichment angle. If Musk benefited competitively from knowing OpenAI's internal direction while building XAI, communications touching that could matter. And the courtroom dynamic made that very concrete. Under cross-examination, per TechCrunch, Musk admitted under oath that Tesla is not currently pursuing AGI, directly contradicting a tweet he'd posted just weeks earlier, which is exactly the kind of credibility issue that makes discovery into his other companies attractive to opposing counsel.
So did any of that outside company evidence actually move the needle for OpenAI at trial? Or did the jury end up going somewhere else entirely?
The jury never got to weigh the merits. Per MIT Technology Review, the unanimous advisory verdict was that Musk had sued too late, and Judge Yvonne Gonzalez-Rogers immediately accepted it, so his claims were barred by the statute of limitations before the substance was ever reached. Musk says he's appealing and calls it a calendar technicality. So the question of what his Tesla and SpaceX records might eventually prove and how far courts will let that discovery go could come back if the case reaches the Ninth Circuit. If Musk v. Altman Daily has you tracking the AI race, try the Data Center Daily, a daily briefing on AI compute, hyperscaler CapEx, the power grid, semiconductor supply, and energy markets reshaped by intelligence at scale. Find it wherever you listen to podcasts. If you want to dig further, we've put links to every story from today's briefing in the show notes. Follow the threads that caught your attention there. That's Musk v. Altman Daily for this Wednesday, June 3rd. This is a Lantern podcast.